Good morning. Welcome to the First District Court of Appeals, and happy Monday to everyone. I hope everyone had a great weekend. Before we get started, I want to acknowledge that we have a couple of community members here from AJC, and we also have some scholars here from Walnut Hills High School and West Claremont, so I want to welcome them to today's proceedings. We have three cases that are scheduled today that are both on the docket and scheduled for argument. So for the guests, what that translates to is each case will be about 30 minutes, which will be about an hour and a half total as far as the court part of your day today. So the three cases we have are case number C240636. That's the first case that's scheduled to argue. That's Anthony Bruns et al. Versus Carol Adlard et al. If attorneys can please identify themselves and their readiness to proceed.
Bill Blessing and Angela Wallace for the appellant.
And I understand that you're splitting time?
Yes, I would like to spend 5 minutes each and reserve 5 minutes for rebuttal.
Okay, so just so that you know, and then 5 for rebuttal. So just that you know, if the 5 goes longer, that'll whoever's arguing first, that'll go into the 5 of whoever's arguing second. All right.
Good morning, Your Honor. It's Mike Shire with Keating Clee Camp, along with me is my partner Andrew Barris. And Your Honor, I also made you so bold introduce to you some guests that we have, and that is the summer associate class. And KMK came along to see what things are going to be like in the real world.
Okay.
And so either go easy on me or...
Okay, so in other words, give them a real show. Let them know it's hard.
Thank you.
And so what schools are they from, or what school?
May I ask them to...
Absolutely. What universities?
Everyone goes to UC besides me, who goes to Vermont Law.
Okay, well, welcome. Well, very good. Well, we have a good, so I will extend to your KMK interns. The students that are here and the community members, they're going to engage in a behind-the-scenes tour after the proceedings today. So if it's okay with KMK and they have the time, they're welcome to stay and join us for that.
Absolutely, Your Honor. That's very gracious offer. Thank you very much.
All right, thank you. All right, and you're not splitting time?
Correct.
Okay.
It's all on me.
All right, and you got the whole 15 minutes. All right, so the next case scheduled to argue is State of Ohio versus Tony Thacker, case number C240523. If attorneys can please identify themselves and their readiness to proceed.
Morning, Your Honor. William McGowan on behalf of Mr. Thacker, and I'm prepared to proceed. Thank you.
Thank you.
Good morning. Scott Neiman here on behalf of Lord Wessels on behalf of the state.
All right, well, thank you for being here. All righty. And then the last case we have for argument is case number C240446, State of Ohio versus Anthony Thompson.
Good morning, Your Honors. Brian Perkins on behalf of Anthony Thompson, ready to proceed.
Good morning, Your Honor. Ron Springman on behalf of the State of Ohio. We're ready to proceed.
All right, thank you. All right, so we're going to begin with Bruns versus Adlard. And Attorney Blessing, are you going to argue first? And so I know you have 5 minutes, you're reserving 5, you're deferring 5 to your colleague, and you can start whenever you're ready.
Thank you. May it please the court. The issue that I'd like to present to the court this morning is an issue under Rule 56 of the Civil Rules and the Ohio Constitution, really, which is the backup on that.
Is there a particular assignment of error that you're beginning with, or is this an issue that applies to all 4?
It applies throughout.
Okay.
The question is whether under Rule 56, in a motion for summary judgment, a court may ignore the testimony of certain witnesses. And secondly, on those witnesses that the court does not specifically ignore, is the court permitted to pick and choose as to what part of the testimony it accepts and what part of the testimony it discredits? So the next question is related, and that is whether under Rule 56 it's the role of the trial court to make determinations of intent. If
So are these issues of law that are well settled, or is your challenge an issue of law, or is your challenge whether the trial court properly applied the standard in summary judgment and didn't weigh the evidence? I'm trying to understand what you're
it's
challenging
the
here.
latter, we contend and submit that the trial court ignored evidence that we presented, the testimony of witnesses, deposition, and affidavit, and
So I would
and-
suggest that maybe you then go through each assignment of error and share with us how the trial court then violated the standard that governs summary judgment.
Well, the assignment of error is the court granted summary judgment. That's the basic assignment of error. And in that, I would like to focus the court's attention on the first sentence of the court's entry. And it says that the plaintiffs allege that the defendants are liable for the Bruns spending habits from 2009 through February 22nd, 2021. I don't know where that comes from. It's certainly not in the record except in one place, and that is the characterization of the case by my good friend, Mr. Shire, here in his summary judgment motion. So it's obvious that the court just lifted that framework, that framing of the case, not from the complaint and not from the evidence, but from,
Can I
The movement's
focus you,
brief.
though, on the conversion
yes,
claim? So my understanding is that there was a list that was several pages long that was presented in the trial court listing the alleged conversions that took place.
in interrogatory answer, yes.
Correct. Okay. And then it seems to be on appeal that you all have somehow, and correct me if I'm wrong, you've limited your conversion claims to certain events. Or is that not the case?
On summary judgment, that's correct.
Okay. So when we're dealing with, on appeal right now, your conversion claims, I just want to make sure I'm clear of what you are saying.
Right.
There was the theft of cash from a bedroom
That's right.
in 2021. Then there was the theft of the LLC ownership was
Correct.
another one. And then the theft of hundreds of personal items and property in March of 2021.
That's correct.
So that's all we're dealing with regard to conversion now?
That's all we're dealing
Okay.
with on this.
Okay, just making sure that I understand that it was
Okay.
limited, because I know there were other things that were alleged.
Yeah, there were other things. We had evidence of other things, but in response to the motion for summary judgment, we focused on those and presented evidence on
Okay.
those. In fact, we presented evidence in terms of the theft of cash from the two participants who carried out the heist. That took place the court limited it to February 22nd, 2021, but those thefts took place in the weeks following that. And
As I
don't-
understand, they took place around March of 2021, which would have been after the guardianship was in place.
That's correct.
Okay, so I want to turn to, and that goes to the cash from the bedroom, from
Yes.
Sue's bedroom in 2021. I want to turn to the alleged fraudulent theft of the LLC. I noticed that that was not specific, I didn't find it specifically in the complaint. But I also noticed that opposing counsel did not raise during summary judgment that didn't raise any error on pleadings or notice with regard to that particular allegation. So what do we do with that?
That's a conversion that we found out during discovery. And so we included that as part of our claims. And I think
Yeah,
that-
I noticed that it wasn't in the list, but then there was it was a deposition. I think it was the deposition of Sue that brings it to light. And I noticed that you raised it then in the summary judgment.
Yes, and we raised it in summary judgment, and we substantiated it in our major affidavit here was the affidavit of Jim Stratman, which the court below completely ignored. There is no reference to it in the decision, and
Well, the court didn't really go through each of your conversion allegations. It basically didn't it kind of lump everything together and just say that this was, like, she voluntarily gave this money?
right, it just characterized intent, and this is one, the court has no business on summary judgment evaluating intent, but the conclusion of the court below was that she intended for those people to come and take that money out of her bedroom. I don't know how you get there, but nonetheless, that was the court's conclusion.
But going back to Judge Dias's focus on the LLC, what was the genuine issues of fact on that one? Because my understanding is that she was presented with some sort of document on the LLC, and so that wasn't her signature.
So just so you know, Attorney Blessing, you're past your 5 minutes. You're welcome to answer the question, or you can defer it to your colleague to
I'll answer the question and
Okay.
then sit down.
All right.
The transfer document was presented to her on the date that she was declared incompetent.
So she didn't remember that?
Well, she had a very vague memory of something being presented to her and that the defendants told her she needed to sign it, and she signed it, and it effectively transferred ownership of the LLC.
But didn't she say that wasn't her signature during the depo?
She wasn't sure. This is not in the record. We have two documents, one which we believe is her signature.
Well, if it's
and
not in the
other one
record,
which-
then you shouldn't be arguing it.
That's true.
Okay.
I will say.
Because you're taking your time, then you're taking away from your colleague. Good morning.
Good morning.
How are you doing?
I'm doing well. How are you?
Very good. Well, welcome.
As you, Your Honor, previously stated, the centerpiece of the trial court's decision was that all transfers of funds or property from Mrs. Bruns to Carol Adlard were voluntary. And
But we
this-
do get de novo, so now we have to figure out what do we actually have in front of us.
Right, and so the trial court's decision ignores two fundamental things. Number one, it ignores the mountain of sworn evidence that was presented. And as Mr. Blessing stated, there's no reference in the trial court's decision to any of that
Understood. I want to
evidence.
get back to the LLC, because there is this issue with what Sue was presented with, and her deposition says that isn't what was given to me, and this would have been, that isn't what was given to me, and she doesn't say this after the guardianship was in place, that it presents as if it was something that was presented to her some time before that, okay? So where in the record can we find sort of like the basis of this fraudulent theft of the LLC?
So a couple of places. Number one, in Joe Fussner's deposition, he talks about it. And also in Mrs. Bruns' deposition, she talks about it.
Well, it's talked about in general, but where is the supporting evidence that there was any sort of a conversion or theft of the ownership interests of the LLC of God's land?
So the actual signed document, it is in the record, and I know our brief references it. It's an exhibit to Sue Bruns' deposition. And she talks about in her deposition how the morning she came up, February 22nd, there was some flurry of activity, and Carol gave her a paper and told her to sign it. She didn't know what it was. That might have been her signature. She signed something.
But here's where, here's I think the challenge is that she also says that that wasn't the document, and it appears to have been something that was pre-presented. So it almost feels as if you're asking us to weigh the evidence and make a determination of fact with regard to that document and the presentation of that document.
And that's what the trial court did, Your Honor.
But
They
that's,
weighed
it
the
seems like
evidence.
that's what you're asking us to do.
We're simply asking you to overturn the trial court's decision, send it back to the trial court.
But it
for
is
them
de
to-
novo, so we need to determine, we need to look at everything and look at all your claims and all your subclaims and individualize them and see whether they are supportive, whether you met your reciprocal burden, at the summary judgment juncture and make determinations based on that. So that's what I'm trying to vet out here.
Sure, understand, thank you. And it really goes to one of the hearts of the issue here, and that is that the trial court used solely Carol Adler's deposition and Mrs. Brunn's deposition. And Mrs. Brunn's deposition was taken over our objection, even though she was found to be incompetent by the Hamilton County Probate Court. And we are not arguing that an incompetent person cannot testify, but we do believe the case law says that if she is to testify and if the court is to rely on her testimony, they have to do a further inquiry of whether she is truly competent to testify. Her deposition is
She doesn't
filled
testify, this is summary judgment.
in her deposition, right, which was relied on as sworn evidence by the trial court. Her deposition is filled with many
So it
confusing
sounds like maybe
statements.
you had a burden there with regard to the use of that deposition, if you were going to rely on it for your response to the summary judgment.
We did not rely on it in response to summary judgment, except for to point out instances where what she said in her deposition was different than what was presented by the defendants. Our summary judgment burden was met through the other mountain of testimony, depositions, the affidavit of Jim Strotman, who is a co-conspirator with Carol Adlard, and other statements as well.
So this document was provided to Sue by Carol,
Yes.
and remind me, what did Carol say about it?
That we had to protect God's land.
So she agreed that Sue signed it?
In her deposition, Mrs. Adler denied knowing anything about anything. So she didn't make any statements in her deposition about that document.
Did anyone?
Mr. Fussner did.
Mr. Fussner said that this was her signature and it was turned over to him?
Yes.
Okay.
Yes.
Ms. Wallace, is the unjust enrichment amount or monies or property different than the conversion amount or monies or properties?
No, it's the same pool of money we're seeking to recover. The other thing ignored by the trial court, and I will be brief here, is the February 22nd order of guardianship. And once that guardianship order came down, Sue Bruns was not legally capable of voluntarily transferring any property, any money, any assets. And after that date, the conversions that we're talking about here all occurred after that February 22nd date. So first, the interest in Sac Spa. Second, the truckload of personal items that were converted from God's land property. Appellee's counsel admits that these were taken. They sent a letter saying, hey, we have these, can we return them to you? And that's at Exhibit P to doc entry 72. And then third, the cash was taken in March of 2021.
All right, well, thank you.
Thank you.
And I have reserved your 5 minutes.
Good morning, Your Honor.
Good morning.
Shire, again, on behalf of Carol Adlard. I could probably help a little bit in terms of answering some of the questions you asked opposing counsel. I'm not sure the responses were satisfactory. In terms of the LLC agreement, you'll be able to find that as an exhibit to Fussner's deposition, which is TD 66. It's Exhibit 20. And you'll see there's a conversion case. And a lot of what you'll find that the appellants do, and I think a little bit of the questioning did that as well, as we speak in the passive voice. The defendant here is Carol Adlard. And did Carol Adlard convert any property? And we're on summary judgment. And Rule 56E required the appellants as plaintiffs and opposing the summary judgment motion to put in front of the court some evidence, identify some evidence that would raise a material issue for trial. So with regard to the LLC, what evidence are your honors going to see on your de novo review? Even if you credit the signature on the LLC agreement, that's Exhibit 20 to the Fussner deposition, TD 66, it's signed not by Carol Adlard, who's the defendant. It's signed by Sue Bruns and Joe Fussner.
And what's the date of that document?
It's September 21, 2021, or it's at some point in September 2021, but that property, that tangible property, was transferred to
Joe Fussner. He's not a defendant. And that's part of the problem here. An overarching issue with the plaintiff's claims, whatever strategic or other reasons is, they asserted claims that are recognized under Ohio law, but the way the evidence played out against the wrong defendant.
So they would have a claim against Joe?
I'm not here to tell you yes or no. It seems to be they'd have a better chance of surviving summary judgment if their claim for the LLC conversion was against Joe, for example.
Okay.
Because there's no evidence in the record. Under Rule 56C, they didn't tender a shred of evidence that Ms. Adlard took control of the LLC, possessed the LLC, was the sole member of the LLC
The fact
ever.
that they're alleging that she was involved in this, that she's the one that handed the document and told her to sign it, that doesn't matter here?
Well, I don't think the testimony, I think what the record shows, and it's disputed, is whether she had said that God wanted the LLC transferred. But I haven't seen any citation to law in their brief, in our brief, in the trial court, that is sufficient to make out a conversion claim. Now, you want to make out a fraud claim, an undue influence claim, an unjust enrichment claim against Ms. Adlard, have at it. Rule 15 is very, very liberal in terms of amending pleadings during discovery, as long as it's at a time not prejudicial to the opposing party. The complaint was never amended to assert those sorts of claims against Ms. Adlard, despite the mounting evidence that was coming in day after day, deposition after deposition. Not a single amendment was made to move to add a new claim against her.
What element of conversion are they lacking here, then, if this doesn't make out a conversion claim?
Possession of the plaintiff's property.
What about the cash?
Okay, the cash is a very similar story, and I have two. There's a legal and a factual impediment with regard to the cash. The legal impediment, of course, is the rule in this court and every other court in Ohio that when it's cash specific, when the property's cash, the plaintiff must prove one of two things. Either that cash is identifiable, i.e., it's that cash in that safe and then not letting me into that safe, or B, it's earmarked for a specific account and it was diverted by the defendant.
Now, you cited a case in support of that, and it's not a conversion case.
Sure it is. Kodu? Don't buy their explanation of Kodu. Kodu was a very important case, and that's exactly what it was. There were 4 causes of action in Kodu, one of which was conversion. The trial court had entered a judgment of attorney's fees and punitive damages against the defendant in that case based on tortious conduct. It found that they made out a conversion claim. This court reversed the trial court on the conversion claim. Why? Because that plaintiff could not prove the cash was identifiable or earmarked. And as a result, it also reversed the tort-based punitive damages and attorney's fees claim.
Wait, was Kodu, all the money that was given in Kodu was cash money?
Correct.
Okay.
That was cash money given by the guy in Virginia who thought he was going to marry the
Well, wait a
woman
second, this
in
was,
Ohio.
he wired money.
Well, okay.
But isn't that a big difference? Isn't that like it becomes difficult to trace when it's commingled with other funds? And this sounds like your option A. This is identifiable cash that was not in a safe, but in a room that was taken out of that room. They may have then put it in some other commingled space, but the other person involved had no ability, was not in like a wire transfer or a bank situation where it was commingled funds.
Well, cash is always at some point somewhere, whether it's in a bank account and then transferred out, whether it's in a safe and then taken out. If you read the case law, the principle that the cash has to be identifiable is it has to be the specific cash or coins. It's not that at one time was held somewhere, because that would vitiate the rule. Cash is always held somewhere at some point.
So what should their complaint have been? What should their count have been? Civil theft?
Civil theft, unjust enrichment.
So they have unjust enrichment, and she just told us that the unjust enrichment was the same claim as the conversion claim.
Well, she's wrong, because the unjust enrichment claim is asserted against a single defendant, and that's a charitable organization, Healthy Visions. There is no unjust enrichment claim against Carol Adlard. The unjust enrichment claim is Mr. Bruns in his capacity as guardian against Healthy Visions. And there was no evidence, none, that Ms. Bruns transferred any money to Healthy Visions on that point. So this answer that it's this big blob is absolutely incorrect and unsupported by the record. They put in no Rule 50, they did not comply with the Rule 56E requirement to put in evidence that Healthy Visions received money from Sue Bruns. She did not. In fact, the only evidence, she said she doesn't remember ever giving her personal money. It was the Bruns Family Foundation, and counsel specifically disclaimed representation of Bruns Family Foundation, and it was not a plaintiff in the case. So, Your Honor, whatever you understood Ms. Wallace to say, Ms. Adlard was not the unjust enrichment defendant. And again, it's this bizarre situation. I can't explain it. I'm not there. I didn't represent her.
Could you help me, though, on a situation where cash is stolen out of a bedroom? Are you saying you can never bring a conversion claim for a case like that? Or if I said, yeah, I had cash in my bedroom, hidden around in different places in my bedroom, and somebody came in and stole it, and there's evidence that they actually did take it out of the bedroom?
Excellent question. I hope I have an excellent answer.
Okay, good.
So Fussner and Stropman both asked, right? These are the guys that took the money. By the way, there's no evidence Adlard ever had that money, but put that aside for a second. Those two are the ones, all the evidence is, whacked up the money in Kentucky. Then
The evidence is they went into the bedroom and took the money
well,
out.
who's they? It's Stropman
Right.
and Fussner.
Correct.
And isn't the
evidence
evidence that, on whose direction did they go in and take the money? What's the evidence with
Stropman
regard to
says
that?
it was, Stropman said Adlard asked him to do that, but again, that's not a conversion claim, but that's in the record. But those two went and took the money. Then Stropman testifies, their star witness, that they whacked up the money and put it in a bag, but he doesn't know where that bag is. And once Fussner left, he never saw the money again. And no one's ever mentioned that bag. And now, to your question, Judge Krause, if that bag was found, that specific bag, there was evidence that that was the bag that those guys put the money in, that bag was transported to Montgomery, Ohio, and it was in Ms. Adlard's home, and she possessed it, that's a different case. That you can
You
make
have to find the exact cash.
Correct.
Somebody steals cash out of your bedroom, and you can't mount a conversion claim unless the exact cash is found later?
And a civil conversion claim, that's absolutely
Okay.
correct. That is the law.
So
and
it
that's
would be
because-
what? What would be the actual charge that,
Unjust enrichment, civil theft.
okay, but not conversion?
Correct.
Okay.
Correct.
So this then, in your mind, is a failure of pleading. They should have amended their complaint to make it civil theft and conspiracy.
Yeah, well, their conspiracy claim didn't work, but Your Honor, I don't want to judge counsel's decision-making, my point is this: it's the wrong claim against the wrong defendant. There's no, under Rule 56E, there's no evidence, and if you look at the elements of a conversion, there's no evidence that Adlard possessed any of Ms. Bruns' cash, any of her tangible property, or the LLC.
So
It's a
which
problem.
which
It's a problem to
element
have.
on the cash, which element of conversion fails?
That, well, two. One is it's not identifiable or earmarked, and that's meaningful. That's a legal defect. Two, there's no evidence in this record, other than in their interrogatory response, one entry. In 2014, it shows Ms. Adlard received $14,000 11 years ago. That's the only cash, and that's beyond the statute of limitations, right? They can't go beyond 2018. But that's out of the hundreds of thousands of dollars in that interrogatory response, there's only one entry where it shows cash was given to Adlard. And there was no other evidence, it's just that, but it's a verified $14,000. That's it, but it's in 2014.
When you say given, you're talking about directly given.
That's what that implies in the interrogatory.
Okay. Do you want to talk about the intentional infliction of emotional distress?
Sure. Do you have any questions, or you just want me to start talking?
Just start talking.
Okay. So there are two plaintiffs in that against Ms. Adlard. Let me start with Franz. Franz has three problems, legal and factual. One is she, through her counsel, didn't put in any evidence consistent with Rule 56E that Ms. Adlard intended to cause her, Ms. Franz, specific emotional distress.
Well, is it intent or is it recklessness? I mean, isn't there like a recklessness piece?
Not
too?
that I'm aware of.
So
In
it ha-
fact, it fits the prototypical law school hypothetical in, speaking of the law students here, they might be able to verify that, but of the case where a bystander is standing on a corner, sees a terrible car accident, bloody mess, they don't have a tort claim against the person that caused the accident because that person didn't intend to injure.
So you're
Even though that
saying
person-
recklessly is not part of the intentional infliction of emotion?
No, I've never seen that. In Coors, this court laid out the three elements. One is not reckless. And the Ohio, it's you need to have the intent to harm that specific person. And no conduct of Ms. Adler was directed at Ms. Franz. None of it was intended to impact Ms. Franz. Her focus was on.
Are you saying that cannot be ascertained by circumstantial evidence? Is that what
Correct.
you're saying?
Well, I haven't seen any circumstantial evidence in the record.
Okay, so it
And-
could be ascertained by circumstantial evidence, but there is none to point to in this case, is that what
There
you're
is
saying?
no evidence whatsoever that the intent of Ms. Adlard was to cause distress to Ms. Franz. But secondly, there's no evidence of any serious or severe emotional distress. All there is in this record that this court can look at on de novo
Now, as
review-
I understand the intentional infliction, it's asserted as to both Sue and her daughter Franz, is that right?
Well, both Franz and Sue, through her guardian, have claims for the distress. I was focusing solely on Franz right now, so
Okay.
she's got.
That's
her
what it's,
second
that's
issue-
why I'm asking the question, because
Yeah, no,
that's what it
abs-
sounded like to me.
No,
Okay.
absolutely. There are two separate claims. So the one claim against Franz fails on summary judgment because she didn't even see Ms. Adler for 10 years before she walked into what appears to be some sort of a bizarre.
Are you saying that there's zero case law out there to support that a relative in close relationship to the, I'm going to call it the victim, okay, that they don't have standing for an intentional infliction of emotional distress?
Yeah, I don't think it's a standing question, Your Honor. I think it's more, have you met that element of the claim under this court's Coors decision? There's no, I haven't seen a case like that. The cases I have is that the plaintiff develops evidence that the defendant.
Have you looked at the restatements on this issue? Because it seems like the restatements, the more recent restatements seems to be a little bit more ample.
I'm sorry?
Have you looked at the restatements on this issue?
No.
Okay.
No, what I've looked at is this court's case law that I found to be persuasive. So there's the intent, there's a lack of severe and serious injury. The Ohio Supreme Court defines as neurosis, psychosis, deep depression, that sort of thing. All we have is stress causing an arrhythmia, and I'm sorry about that. It doesn't make me happy that someone is stressed out and has an arrhythmia, but the testimony on the record, you'll see, Your Honors, is that was caused by the probate court hearing when people other than Ms. Adlard showed up with a lawyer and put on evidence that apparently disturbed Ms. Franz and caused her immense stress that caused the arrhythmia, and that's what the evidence is. I'm arguing the record and what you'll see in the record, and
So in
that's,
the time you have remaining, unless there's any other questions on Franz, can you address Sue?
Yeah,
on
of course.
intentional infliction?
So that's a pass-through claim by Mr. Bruns. If you look at Sue's deposition transcript, she could not identify any physical or emotional harm that she suffered as a result of Ms. Adlard's conduct. That should be the beginning and the end of that inquiry.
Well, we have Franz's discussion as to impact on mom. What do we do with that?
Well, Franz's.
No, I'm sorry, we have a physician's, actually. The physician's, there was a submission with probate that became part of the record here.
Well, ironically, that supports our view. It's Dr. Sigward, and he actually testified that cognitively and intellectually, Sue Bruns was completely normal. So, and that's his area of expertise. He's a psychologist. And you'll see, it's absolutely amazing. When I went through the record getting ready for argument, I'd forgotten that. But his testimony actually was that she was 100% normal in terms of her cognitive abilities and in terms of her intellectual abilities. He said something about, well, she became palpably nervous when talking about the prayer group, but palpable anxiety doesn't meet the severe and serious element of the Supreme Court's Paul decision. So the
Do you
best.
do you think that a diagnosis is required?
I think I think in most cases that I've litigated, I've seen the defendant come in with an expert, either an expert or a treating physician diagnosis. They have neither here. What they have is an expert diagnosis that cognitively and intellectually she was 100%. He says that all he noticed was palpable discomfort or anxiety. I forget what it was. And that just doesn't meet the standard, Your Honors. I feel bad that they made her meet with someone that gave her anxiety, but it sounded like Dr. Sigward made her anxious, not Carol Adlard. And then in terms of Lalich, who's the sociologist, no one ignored her testimony. She had nothing, she doesn't have the expertise to talk about emotional distress. She's got expertise to talk about group sociology, how do groups function, how do cults function. That may or may not have been relevant to any of the issues in this case, but certainly was not material to the conversion claim, the unjust enrichment claim, the civil conspiracy claim, and so or the intentional infliction of emotional distress claim. So at the end
I'm
of
going to see if there's any other questions from the panel. All right, well, thank you.
Thank you, Your Honors.
If I may begin where he ended. Counsel was correct that Sigward's deposition found Sue Bruns to be otherwise cognitively and intellectually intact. But he found her to be incompetent to manage her own affairs and to take care of her
But
property.
that's not what we have in front of us. We're not challenging whether there was enough for competency here, right?
Right, but solely, she was incompetent solely because of Adlard's conduct. He found, his finding, his deposition, his expert evaluation, his statements, was that she was incompetent due to Adlard's treatment of her. That's what his deposition says. That's what his report says.
Do we have to find that it was intentional? I mean, is that the only, or is recklessness a piece of this?
I believe recklessness is a piece of this, Your Honor, and
Because intentional is hard to show.
it would be nearly impossible for anyone to ever succeed on an IIED claim if we had to prove that I set out to intentionally inflict emotional distress on you. Right.
Okay.
And reckless has been consistently part of that standard. As to the IIED claim against by Mrs. Franz, Dr. Franz, counsel stated that there was no evidence of any intent or any reckless actions against Franz. If you review Dr. Franz's deposition, there's a very detailed description of exactly what Carol Adlard did to Dr. Franz to cause emotional distress. She separated her from her father as he was dying. It's a very lengthy and heartrending description of what happened, and that's in the record. It's also summarized in our brief as well.
Ms. Wallace, what do you say about the cash?
Your
Does it
Honor,
have to be in a bag somewhere else, or can it be cash that's identifiable in a room?
if it had to be in a bag somewhere, I think that we would just have to omit conversion as a possible claim for any plaintiff.
Well, that's what they're arguing. They're
Well,
saying that
conversion
it
of
should be a
cash.
theft claim or some other claim, and you all pled it wrong.
And I think that's inaccurate.
Okay.
Which is interesting because obviously the theft would have subjected them to treble damages.
Right. There is no court in Ohio, this court or the Supreme Court, that has agreed with counsel's view of conversion law. It just doesn't exist. We very extensively briefed the CODU issue, so I won't bore you again with that.
So what do we do with the evidence to support the notion that Adlard had directed the two individuals who went into the bedroom and had taken the cash? Is that relevant or not relevant to the conversion?
It absolutely is relevant. She directed them to take the cash, and she also received the cash. Jim Strotman's deposition, his affidavit, and I believe his deposition as well, states that cash went to Carol Adlard. So the notion that she never received anything belonging to Sue Bruns is just inaccurate.
And what was his relationship to the parties?
He was one of the co-conspirators. He was part of the prayer group, and then in November of 2021, he was excommunicated from the prayer group. But at the time of all of the relevant actions, he was a member of the prayer group and a co-conspirator with Carol Adlard in stealing items. There's also ample evidence in the record that Carol Adlard stole tangible items from Sue Bruns. In fact, she had several moving vans, I believe 3, that came down to God's Land in Manchester.
How were those tangible items identified as occurring after the February guardianship? How are they identified in the record specifically?
How do we know they happened after February? Is that your question?
How are the actual items that were taken outside of the cash after the guardianship was in place, how is that identified in the record? How do we know what those items are?
Doc 72, Exhibit P, is a letter from counsel for appellee that states our client has these items in her possession.
So it's a list of the
It's
items
a
that you're
list.
talking about.
Yes, Your Honor,
It's a list identified by opposing counsel in discovery?
it is.
But is there a
Well,
date
how
to
is
that?
there, how do you tie that to something being taken from an actual location
And
at
how do
a
you-
time?
I'm sorry, and how do you tie that to the timing? Because I'm interested in the timing of it being items that were taken after the guardianship as opposed to before the guardianship.
So there are text messages in the record that where Mrs. Adlard states, "I've got moving vans coming, and we've moved these items to a storage unit in Blue Ash." Those are statements by Carol Adlard. That was after, so the guardianship was February 22nd. They got very nervous, and she ordered everyone to move out of Manchester. At that time, the text messages show moving trucks came in, loaded all that stuff up.
But
took
we
it
don't,
to
but those
storage
text
units.
messages don't talk about these specific items. The only thing about the specific items is this list that you discussed.
It's a couple different places. It is in the interrogatory responses from the Guardian. It is in the list, and there's also pictures of the storage unit with, items loaded up. So, I mean, it is traceable. These are items that also are discussed in Sue Brun's deposition of things that she had bought that were that were on location in Manchester. And so, I mean, there's no tracing device, unfortunately, on, the boxes of food or whatever, but
So-
there's certainly enough.
So
there.
assuming what you're saying is correct, that it's in the record, I noticed that you don't identify it in the brief. So don't you have an obligation to do so in your brief before us?
We didn't identify where
What-
that is in the
What
record?
those items are that were taken, that you're asserting, and it's already been established that there's 3 things that are being asserted in conversion, that they occurred after the guardianship, and that we're talking about those personal items that I believe you identified as being taken in March. But none of those items are actually identified in the brief in front of us.
We felt it was most expeditious, Your Honor, to provide the list given to us by defendant's
But
counsel.
we've already established that the list doesn't have a date on it. So
The-
how do we know as a appellate tribunal that those are related to the date
The list
without,
has, I'm sorry.
it sounds like you're asking us to rummage through the record.
Not at all, Your Honor. The list has a date when the letter was sent, which was May of 2024. And there was nothing moved out of Manchester until March of 2021. That's when all of the moving took place.
So you're saying that that list identifies itself as items that were taken from God's land, basically, and
Yes.
taken from God's land after the guardianship?
Yes, Your
Okay,
Honor.
well, the record will speak for itself. All right, thank you so much.
I assume I'm out of time, is that correct?
Thank you, yes. Unless there's any, I want to make sure, unless there's any other questions from the panel. All right.
Thank you. Thank you all.
Your Honor, may I address Judge Nestor's question about our letter? Okay.
Because that'll just open up a whole tidal wave. And we have people waiting for their time. So I want to be respectful for all counsel that's here this morning. All right, thank you, everyone, for your arguments this morning and your presence. We will take the matter under submission, issue a timely decision, and I wish you all a wonderful afternoon. And I guess I'll be sequestering your interns for a little bit further of the day.
Sure, that's
All right,
Have a good day.
all righty.
I take a moment.
Yeah, of course. You don't have to rush. Well, I guess we won't be sequestering your interns for the rest of the day.
Well, I'll
It's up to them. I mean, it's fine either way.
Yeah, no, not a problem. But thank you again, Your Honor.
All righty. Good morning. How are you doing today, Attorney Gallagher? How are you doing?
I think so far so good. We'll find
So
out
far,
about
so good?
20 minutes or so.
Did you have a good weekend?
I did, thank you so much.
Wonderful. Well, you can start, and first out, would you like to reserve time and how much?
I can reserve 5 minutes, I'd appreciate it. Thank you so much.
Absolutely. Whenever you're ready.
May it please the court? You know, on October 20th, 23, Mr. Thacker ran from the back of his house to the front of his house. He didn't leave that house. He didn't go out onto the street. He didn't go down to the sidewalk when dealing with the 5 or more masked men who came in thereafter bashing their way through that front door. And it's because of the fact that he didn't run down the street, he didn't chase anybody out, he didn't go outside his house, and the fact that the men were armed and were violent, I think that sets this apart from most of the other cases that the state cites in its brief in terms of whether or not you can argue about advancement. And this was a really clean trial, and by that I mean, as you can see, the only errors really sort of that we found and that we raised are about the the weight of the evidence, as well as then the prosecutorial misconduct that occurred during closing argument, and not during closing argument, but more importantly in rebuttal. So the last words that this jury heard over and over and over from this prosecutor had nothing to do about the reasonable belief of fear, or whether or not he was in fear by advancing. That would be a fair comment on the evidence, that how could you be afraid if you ran to the front of your home and still chasing people with a gun? That's not what it was. It was a misstatement of law talking about the fact that advancement is somehow illegal, that you don't have the right to advance.
And how is it that the bench's jury instructions was not curative of that?
I think that, because it really doesn't address the issue about advancement at all. I don't think it necessarily cures that. It's a correct statement of the law in terms of self-defense. But the problem is that the jury instructions themselves don't really discuss whether or not someone has the right to advance or not advance. And that's what occurs here with the prosecutor talking about the fact that when talking about duty to retreat, the jury instructions don't mention how to define a duty to retreat. It just says that there is no duty to retreat. But what happened was, as the prosecutor said, no duty to retreat does not permission to advance.
Well, isn't that issue kind of almost always a factual issue? When self-defense turns into offensive action, isn't that almost always going to be fact-specific and require a fact finder to make a determination of when self-defense ends and offensive action occurs?
I think that goes more to the reasonable belief. But to make a blanket statement that no one can advance would be a misstatement of law. If so, then the Mitchell decision was improperly decided by this court. Because in Mitchell, the court found that the prosecutor misstated the law and that the defendant had a right still to be able to advance when faced with an armed person.
What was the statement of the prosecutor in that case? How is it different?
How is it different? Yeah. Because it really wasn't about advancement at that point. It was more about self-defense and about, but what I'm saying is the prosecutor made a misstatement. But what I'm saying is what Mitchell talked about was the fact that, I think, in fact, what Mitchell said, because it's my wife that argued it, so I got to try and remember this, but it was Mitchell in the face of someone with a knife still advanced and he had a gun. And the prosecutor said, how can you reasonably believe in your reasonable belief of self-defense if you're advancing on somebody with a knife? You're not in fear for your safety. That was a misstatement of law. But what the problem was is that this court in Mitchell said you can still walk towards and advance. And this is different than, say, this court's decision in Donovan recently, where Donovan left the home. And that's what the court focused on, was he, who had been pistol whipped and harmed, left the safety of his home and went out the street in an attempt to thwart, and it said re-engage. Here, there's no attempt to re-engage. This is one continuous activity. This is him still staying in his home. This is him not going down the street or down the sidewalk.
Didn't he basically, he was not indicted for the person he shot inside the home?
Correct.
And the other people were outside the home and arguably in retreat at the point where he was engaged in the actions that resulted in the criminal complaints in this case.
And I accept that, and that's a fair argument to talk about reasonable fear of belief. But to make a blatant statement that you cannot go from the back of your house to the front of your house, because that's what the prosecutor said, you cannot advance. That is not permitted. You cannot go forward.
Is that really true? Wasn't the statement more in the context of argument about where that action stops, where self-defense stops and offensive action begins?
But it talks about no, because the reason I would disagree with you is because it was in the context of no duty to retreat. It took the no duty to retreat statement and made it, that means no authority to advance. And you cannot put those two together because that's the misstatement of law. To put those two together, to say he doesn't have a reasonable belief because he advanced, that's a fair argument. You cannot go and re-engage, that's a fair argument. But
Well,
to say
I guess my question is really, like, it seems to me, both before and after closing argument, usually the trial court says something like, closing statements are not evidence, and I'm going to instruct you on the law. What they said effectively was not the law, it's argument. Wasn't this really just closing argument?
If that's true, then we might as well throw out the United States Supreme Court decision in Hastings that says the repeated arguments of misstatement of law by a prosecutor in closing arguments requires reversal. That's what Hastings said.
Was this on rebuttal? I mean, when did the prosecutor do this?
It was in rebuttal.
Was it rebuttal?
It was rebuttal.
Okay, so
You're facing with the same prosecutor we just deal with in Grubbs, which was decided by this court, making misstatements of law about self-defense.
So
in
this
closing
advancement theory was not brought up in their initial closing argument?
Right.
So the defense didn't really have the opportunity to stand up?
And if you could, to correct the law,
Correct it.
because this is a misstatement. Before it was arguments, right? It's arguments about facts and this. But this is a prosecutor telling the jury a statement of law.
How did they frame it that the jury wouldn't know that it was argument versus law? And how repetitive was it? Three times?
Okay, well, 1, 2, 3, 4, 5, within a short rebuttal argument. Not once, not twice.
So
But
no
that's
duty to retreat does not mean advancement?
No duty to retreat is not permissible to advance. No duty to retreat does not mean that you get to run towards the person. He has no duty to retreat and run back or run to the back of his home, but he does not have permission to advance. He does not have permission to run to the front of the store. No duty to retreat means no permission to advance.
I guess I was reading it more that the prosecutor was saying, not necessarily that he didn't have permission to run to the front of the store, which you just read to me, was more so that once he got to the front of the store and the people were out of the store, getting in a car to leave, that you couldn't keep shooting out of the store. I mean, I thought that was the whole point of the whole thing.
And like I said, I think that goes more to reasonable fear, but to talk about advance, right? Because the statement is go from the back of the store to the front. If it was, you have no right to stand at the front of the store and shoot out of the store, then we can talk about it. But what she said was he had no right to advance from the back to the front.
Well, what did the defense argue? Remind me what the defense argued in closing regarding him standing at the door, shooting out the door as the people were
Did he
leaving.
reasonably believe that he had the right to self-defense, and part of it was because the brake lights were still on that car and that car had not left
He thought
yet.
they were going to come back.
And he wasn't sure if they were coming back or not, but he had just been attacked. And then remember, this is the third attack.
Because, I mean, that's the whole point of this entire case and why he was charged, is because he was standing at the door shooting at people that were in a car trying to leave, right?
But that's only if you, the question is, what was in his mind, right? And that was the fair question everywhere. What is in his mind at the time?
But the
of
judge
reasonable
properly
belief?
instructed the jury. You're just
Absolutely.
blaming the prosecutor for making this advancement theory.
Well, because it's a misstatement of law, and that's the problem. It's said 5 different times as a misstatement of law, and that's what these courts have to deal with.
And it was never objected to.
It was not, and that's why I have a little bit more of a burden in terms of plain error, but
It's not like the prosecutor said something like, in a moment, the judge is going to instruct you that you may not advance. I mean, the prosecutor, in the heat of rebuttal, is making an argument about the factual circumstances, really, that have been raised in closing argument.
if this was a factual argument, I would tend to agree with the court. But these were statements of law, and these were assertions about duty to retreat. They were put in a context of not facts, but the duty to retreat. Exactly what the the instructions are going to talk about.
But your big issue is that when they were saying, and I understand the problem, they were saying he wasn't allowed to run to the front of the store.
Correct.
I get that. But I thought the crux of the whole case was him
I-
shooting out the front of the store.
Absolutely, but what she's now telling this jury, which is what? Even before you get there, he's lost the right to self-defense. Before you get to the front of the store, he's already lost the right to self-defense. He's got no way to go from the back to the front. He's got no, and that's what she's saying over and over again. And if this was an isolated incident once in the heat of the moment, I get it. But this was 5 repeated arguments about the exact same point. This is not a heat and a slip of a tongue. And this is not a prosecutor who hasn't done this before, because in Grubbs, it's exactly
Would
what
you
occurred.
agree, though, that no duty to retreat means you can't stand at the front of the store shooting out the door?
I think the question becomes whether or not, what those circumstances are. And
When
I think-
people are retreating in a car?
Well, whether or not they retreated and were intending to leave is a definite question for the jury to have to deal with, because what Mr. Thacker testified to and what he told the police was, I didn't know what they were about to do. Their brake lights were on, right? These were not, the car was going off. The brake lights were on. Are they getting back out? Are they going and getting a gun? Are they getting 2 guns?
But does he shoot, or does he wait and see if they're going to come back?
But I don't necessarily know if that's a requirement.
Right,
And I think that's
right.
for a jury to decide whether
Right.
that's a
And
requirement.
they did.
Right, but that becomes, and they didn't, and understand, we don't have a conviction on all counts. The jury still found him not guilty of some counts. And so the question is about the advancement. It really, really is.
I only
And
have
that's-
one question, and you're out of time, so I'm going to give you like a minute, okay? And it's really 2 pieces to it that are intertwined, okay? So one, so we got to look at this subjectively and objectively, right? So wouldn't the brake lights be on when the person puts the car in drive because they're putting their foot on the brake to put it in drive? But hold on.
Right.
And then intertwined to that is, what is the evidence to support that he believed that he was under a threat at the moment that he shot those 6 shots that are at issue here?
Yeah, I think there is some support from his own testimony about the fact that he was still afraid. And we had to put into his mind the fact of what's happened on 2 prior occasions, right? In that same store, he was stabbed and burglarized, the victim of assault then. And just a month before, people threw rocks and tried to break into that window just a month before that. So you had to put those 2 in there as well. And we're talking about being faced with 5 or more masked men, all in black, who were coming in there. And we're talking a matter of seconds, and there isn't a lot of time through all this. And so to sit there and say that there's tons of time to contemplate the next move, I think is a difficult one to say and take time to ponder what's going on. Is the car going to go and take off? I agree with you. That's a fair question of fact for the jury to determine. Is it going to go into reverse? That's fair. But Mr. Thacker's testimony was he still didn't know what was going on. And we're not even sure. And there is no evidence.
He's saying more than that. He's saying, I felt under a threat.
Correct.
He has to feel under a threat at the moment that
And
he
he
shot.
did talk about the fact that, yes, and there was still.
Imminent threat.
Well, I think that's.
Great harm.
Absolutely. But that goes really to the manifest way, but not to the prosecutorial error that I think alleges in here. But
But
there is no
the reason
evidence.
I'm asking it is I'm trying to figure out the prejudice is what it comes down to. Because I but,
Get that. And I think that.
so in
that's-
other words, if I were to agree with you, I'm trying to figure out the prejudice.
Well, I think, what the test is, unfortunately, that I have because of the plain error, which is, it's got to be clear beyond a reasonable doubt that absent that misconduct, the jury still would have convicted. And that's really the test, if you find prosecutorial misconduct. And that's clearly, I think, and we talk about that. Because there's no evidence that.
I'm going to have you,
I mean, there is no evidence
You're
that
gonna
the
reserve
shot
your
definitely
time.
went through the car. I get that. But I wanted
Okay.
to finish while we have this thought. The shot didn't, there's
We're
no
done.
evidence that the shots went into the car that hit AC.
Attorney Gallagher, we got it. Thank
Okay,
you.
sorry.
Thank you.
Good morning.
Good morning. So I have a direct question for you.
Sure.
Okay, because there are 5 things that are complained of that are in the brief. There's 2 of them, as I read them, that go towards the assertion that the duty to retrieve does not give permission to advance, and specifically from the back to the front of the property of the business. Okay, so how is that not error, even on plain
When you
error
look at the
review?
case law from this court, when you look at State versus Jackson from 24, that a defendant who willingly advanced towards a volatile situation is considered at fault for the physical altercation. When you look before that to State versus Worth, 2023 case, once a person against whom defensive force is used is no longer either on the defendant's property or a threat, or when the defendant has succeeded in expelling the other person, then the privilege which the defendant operated on is over.
I understand that and that partially goes to like now whether there's actually prejudice, but I want to get to whether there's error because there are two specific statements that go to a statement that is telling the jury by the prosecutor that Thacker did not have the right to go from the back of the store to the front of the store.
Again, I think when you look at, if you look at that in isolation, it can be read.
And one of them is very specific.
But when you,
Does not have the permission to run to the front of the store, very specific. The other one, duty to retreat and run into the back or run out the back of his home, also quite specific.
I think what she was talking about didn't have to run out the back. That was specifically explained that he did not have a duty to retreat. He did not have to like, uh-oh, there's people in my house and run away. When you look at the whole case, and especially the closing argument as a whole, not in a vacuum, when you look at it in a whole, what she was doing was addressing Mr. Thacker's arguments and addressing whether or not he was still acting under a belief that he was acting in self-defense when he walked to the front of the store. Now, if he just walked to the front of the store and looked out, he has absolutely right to do that. But it's when he looked out the store, and you can see this in the video. When you watch the video, you will see that he walks to the front of the store, he looks out, sees them, and then starts firing. And it, as you said, at that point you can see that the brake lights are on. They're getting ready to leave. That he has expelled them from the store. He has removed them from his, what is effectively his home.
So, what, how do you respond to the idea that this is a repeated misstatement of the law that somehow is so egregious that it misdirected the jury?
I don't think it is taken in the context of this case a misstatement of the law. I think it was just argument by the prosecution, and if there was any misstatement in the law, it could have been objected to and it was not, and it was cured by the trial court's instructions, which properly set forth all of the law in self-defense.
So you're looking, as we should, we have to look at their rebuttal as a whole, but it seems like you agree that there were a couple misstatements of the law. The back to the front, when you're in your own home, that would be a misstatement of the law, right?
That you could not walk to the front of your home?
That you can't advance to the front. That's clearly a misstatement.
That would be, but again, I think when you look in the context, it wasn't that the prosecutor at trial was saying that Mr. Thacker was guilty because he walked to the front of his house. It was once he got to the front of his house and he looked outside and then waited a second and then started shooting.
So you're really getting to the prejudice there.
And there is.
In other words, if there was error, that
there certainly
that
is
it comes
not.
down
And
to whether he really, the jury determining whether he felt that he was under imminent harm when he did those last 6 shots. That's at issue here.
Right, those last 6 shots are the ones that are at issue. Everybody conceded that we
prior
agreed
ones were
those
fine.
first 13, that was self-defense.
So in other words, you can't just take the closing argument out of the context of everything that the jury has seen, especially the testimony, the video, all that stuff. She's essentially commenting on the facts from the position of the state. But, when does it rise to the level of being so repetitive that it's no longer just a fair commentary?
I think that would depend on the facts and the underlying nature of the case as a whole and the nature of the argument. Again, when you look at this in the context of the whole, when you look at the whole picture, what the prosecutor said during closing was just argument. It was not misstatement of the law.
Is there any rule from Ohio law on that? Like when does fair argument from a prosecutor turn into, it seems to me like if it's clear that they're misstating the law, if they just say something and it is in contradiction, like they say, like the judge is going to instruct you and it's just wrong, and then they keep saying that's what the instruction is going to be, then that seems like a clear misstatement of the law. This seems like a description of a factual circumstance that is particular to the case. Is there any Ohio law that directs on that?
Off the top of my head, I can't point you to any. I'm sure I could find it, but I cannot point you to any off the top of my head. But again, as you said, this case, this argument This was about the facts of this case. This was about asking the jury to look at how the state perceived those final 6 shots. And when you look at this at that level, which is what you need to do, you need to look at everything. This was not error. And even if it was error, it's not plain error. And to demonstrate plain error, it's not that, well, maybe the result could have been different, because anything could always be different. Would it have been different? And if the state had misstated the law and then the trial court went along with that and misstated as well, then obviously, yes. But in this situation, the jury was properly instructed by the trial court. No one contests that the jury was properly instructed. And if there was any error in the state's closing argument, it was cured by the trial court at that point. And if it wasn't, again, it fell on Mr. Thacker to raise this below and to object to it. If this wasn't a plain error standard, maybe it'd be
And this was interesting to me about these cases, because this isn't based on any sort of like scientific evidence or anything like that. This is just based on the jury making a credibility determination and a determination of looking at the circumstances and weighing those facts in, right? So when we're looking at prejudice for plain error, the prejudice is whether the outcome will be different, in this case, whether there would not have been a conviction. So it really comes down to whether the trier fact would have weighed all of that differently. And that's much harder, I think, to say that there isn't prejudice than when you're talking about, well, there's all of this other evidence that's supportive of the claim.
I disagree. When you look at this case as a whole and you look at the argument.
But I'm not talking about this case. I'm talking about as a general principle. I don't think it's as clear cut when you're talking about a jury making a credibility determination as on plain error review, whether the outcome would be different.
Again, I'm going to have to disagree with you on that. I think in this situation that just because the jury was making credibility determination doesn't change the analysis. It's still whether or not the result would have been
I'm
different.
not saying it changes the
jury had
rule
not
of
been
law. I think it
proper-
changes how to look at it. I think Attorney Gallagher will agree with me. You'll disagree with me.
I'm sure he will. But again, if the jury had not been properly instructed by the trial court, I would, obviously, this would be a different situation. Again, that's assuming that there was an error here, which I don't think there was. But again, juries are presumed to follow the trial court's instructions, and there's nothing here that shows that they did not do that.
Boy, so this is why I'm just trying to parse this out. I thought you thought there was error in some of the comments.
No, I could see how, if taken in isolation, that it could be seen that way, but I really believe that this was just fair commentary on the evidence and asking the jury to apply much of the law from this court about when you are and are not allowed to continue to engage in force.
Saying that he was not permitted to advance to the front of the store, you do not think is error under the law?
Taken in a vacuum, that statement would not be correct.
That's not a correct statement of
You
the
are
law.
allowed to walk to the front. However, when you look at it in the context of the arguments that
Right.
were being made, that's when it changes.
Right.
So, unless there's another
So you're asking us to look at it in the light of the arguments being made, not in light of the statement by the bench on the jury instructions?
Well,
Or on both?
From the first point, I don't think that the trial prosecutor's closing argument was an error. But if it was,
Okay.
that's when you look at the instructions that were given by the trial court and see that any error that may have occurred would have been cured. And again, we presume juries follow those instructions, and there's nothing here that shows that they did not. The only question that the jury had to do with who was in a car. And
So I have this is a genuine question, all right? When the prosecutor misstates the law, are you saying that proper jury instructions will be always curative of that?
I can't say that would always be, but in this case, it certainly was. Again, I can imagine there'd be some extreme situation where maybe it could, but if that case exists, this is not it. And there's no other questions. I think this was very much a weight of the evidence case, and the jury got it right. It should be affirmed.
Thank you. Thank you for your time.
You'd asked about Ohio case law, or federal. Conley versus the Christopheril, and in the state of Ohio, it's Keenan, are cited in our brief. Stand for the proposition of this: repeated misstatements of law can deprive a defendant of his right to a fair trial. And neither one of those cases is to talk about just the fact that a jury instruction can cure that. And the reason for it is because a prosecutor holds a special place, and they talk about the special place. And if you want to talk about the context of the arguments in this case, they were not about statements of fact. What Mr. Goldberg argued exactly, and it was quoted in the state's brief on page 8, as long as he has no duty to retreat, as long as he was in a place where he had a lawful right to be. He did not have to run away.
So in that case, that Keenan case,
Correct.
what was the misstatement of law that was repeated?
Quite frankly, I don't remember.
I mean, it seems to me like if the prosecutor just said, you have no right to advance to the front of your house and then shoot someone who is leaving, it would have been fine.
I'm not necessarily sure, maybe yes, maybe no, but what I'm saying is, but to add more to it then gives more context to what this jury was told, but that's not what this jury was told.
I mean, it seems like it's an isolated statement, and then you have, well, maybe it's not isolated from your perspective. It's in rebuttal 3 or 4 times, but it's after everybody has seen all of this evidence and they know exactly what both sides are talking about. It's not so much that the person went to either the front of the store or the front of their house. It's that they stood at the front of the door or the front of the house or the front of the store and then engaged in force that was offensive and not self-defense. And that seems like a perfectly legitimate thing for a jury to evaluate in a self-defense case.
Absolutely. And had that occurred the way you described it, maybe we'd be in a different scenario. But that's not what happened here. And what we had in here was a consistent statement of no duty to retreat means no duty to advance. That's a misstatement of law. That's not a comment on the facts. That's a misstatement of law. And it's not once, it's not twice, it's 3 times, quite frankly, I would disagree. And then 2 others in that regard. And that's the problem, is instructions are not looked to cure that. We don't look in the case law to cure that. You go to look at the gravity of the offense by the prosecutor in rebuttal, making specific statements, misstatements of law, and they weren't in, all Mr. Goldberg, it says, is he has no duty to retreat. And she says, you're right, he has no duty to retreat, but he can't advance. That's a misstatement of law. And we don't look to jury instructions on that. The Jackson case was a dispute over whether someone, who the first blow was from, and it did not involve a misstatement of law. Worth, and I guess in every self-defense case we're going to talk about Worth. In Worth, if we remember, what happened was Mr. Worth left his home, went out to the street and confronted, and that was one of the biggest problems in Worth. And in here, what we have is someone staying within his own home at the front of it. And what I'm talking about is still the misstatement. I'm not talking about the weight of the evidence about whether or not he should have continued to shoot, because the jury never gets a chance to decide whether that was right if they believe and take into consideration the prosecutor's statement, misstatement of law, that you do not get to go to the front of the store. If you've lost your right to self-defense before you even get to the front of the store to make that decision, the jury never decides whether he had a reasonable belief of self-defense at that moment. That's what this prosecutor did. They robbed this jury of the determination of whether those shots at the front of the store were done in self-defense because of that misstatement of law. They never get to that. If they accept that statement as true, he lost before he even went to the front of the store to make that decision. And that's the problem with this case.
Well, so how do we know that they accepted it as true when there is the instructions of law? The last thing they hear is not anything about you don't have the ability to advance, it's that you have no duty to retreat.
Because that's not the requirement of any law, of any case. Because they get down on the fact, what starts from the Ohio Supreme Court and the United States Supreme Court and Christopher and Keenan is the repeated statements by a prosecutor are the ones that deprive the right of fair trial. That's the problem. That becomes the problem. And what the question is my burden at that point. If someone objected, we'd be in a whole different situation, right? I have a harder burden. I get that. But I believe we've met that. It is not about whether. They don't talk about curative instructions at this point. They don't. They don't talk about the regular instructions to the jury, cure prosecutorial misconduct. We don't deal with prosecutorial misconduct in that way and just say, well, the jury got the proper instructions, so we'll forget all that misconduct because of the last word that they heard. It's because of that special place that a prosecutor holds. That's the question.
And do you think the fact that ultimately, with regard to what imminent danger, that it comes down to a credibility
Absolutely.
determination, do you think that that affects prejudice on plain error review, as opposed to a case in which you also have scientific evidence for the jury to weigh?
I think that, yes, I think that's possible. in the misstatement of law, as I said, I think the problem is it may prevent the jury from that, and I think this court could find that. Those misstatements of law prevented the jury from making that factual determination about credibility at the front of the store about whether he reasonably believed, because if you can't go there.
Because you're basically saying the jury could have not even gotten there, that it trumped them even to getting to the imminent danger portion of it.
Absolutely. You can see in a jury room easily a juror go, wait a minute, he can't even go to the front of the store. We don't even have to talk about that anymore. He can't go there. He should have stayed at the back of the store. He's got no right to go there. And I think that that's the problem. So we don't, in any prosecutorial closing arguments sort of say, you don't look at the fact that misstatements of law are corrected by the, if not, then you would never have that as an error. Because their jury, unless you also had a jury instruction issue. If you had a prosecutorial misconduct and a failure to properly instruct, that's the only time we'll ever have error with prosecutorial misconduct in closing arguments. That is not the law.
So you think if those statements were not made, or if it was sent back for a new trial and everyone was much more careful about what they said in closing arguments, that the result would be different?
Well, first of all, I don't think that's a burden, but yes, I think it's real possible. Absolutely. Absolutely. But I don't think that that's necessary to test. It's not, it really isn't a by-four, it's really the other way around. You have to find beyond a reasonable doubt that absent that misconduct. And that's
Well, that is the plain error burden, right?
Right.
That
Well, with prosecutorial
the error must
misconduct-
have affected the outcome?
I think in Hastings, the United States versus Hastings, they stated a little bit differently when we talk about prosecutorial misconduct in closing arguments, not just straight up plain error.
Okay, so then what are our plain error?
I think under United States versus Hastings, the test is clear beyond a reasonable doubt that absent the misconduct, the jury would have convicted. It's a little bit different, but this
is the same question that Judge Nestor asked, right? I mean, would things have been different absent this misconduct?
I think so. I think so. I think, but it's a little bit there. I think you have to find beyond a reasonable doubt that it would have still been that. And that's a little bit different than the by-four test, but it's a little bit, I think it's a little bit easier burden for me to meet or for this court to find than the normal plain error. And I think that the reason for that difference is because we talk about prosecutorial misconduct changes that sort of plain error as opposed to other error that's plain error.
Okay.
And that's, I think, why the United States Supreme Court did that little switch on the test from a but-for to
The U.S. Supreme Court.
U.S. Supreme Court. United States versus
The
Hastings.
Ohio Supreme Court hasn't done that?
I'm not, you know what, I sort of stopped at the United States Supreme Court. I didn't look to see if you had further support for it. I sort of relied on those guys. If there's no other questions, I'll be more than happy to sit down and shut up.
Well, thank you. Thank you for your arguments, that is. Thank you both for your arguments this morning. We'll take the matter into submission, issue a timely decision. Have a wonderful afternoon. So our last case is State v. Thompson. Good morning,
Your
Attorney
Honors.
Perkins. How are you doing?
I'm doing very well, thank you.
Thank you for your patience this morning. I know
no.
the arguments have run a little long.
No problem at all.
Would you like to reserve some time?
Yes, Your Honor, if I could reserve 5 minutes for rebuttal, I'd
Okay.
appreciate it.
No worries. Whenever you're ready.
Your Honors, as the court knows, it's well established that if a court acts without subject matter jurisdiction, anything it does, any sentence that follows is a nullity. The felony, the jurisdiction for a felony in the Court of Common Pleas is invoked with the return of a valid indictment.
But that doesn't go to subject matter jurisdiction, does it?
I would assert that it does.
What would be the case, or how would you support that?
I
Because-
would submit to the court that in my reply brief, there were 3 cases, I believe, that I cited to, that talks about how failure for the foreperson of the grand jury to sign the indictment renders it to be a nullity.
But
And
isn't, that's where I was getting confused on your arguments, because your first brief discusses jurisdiction only. That's your assignment of error. And it seems to me the case law is very clear that this problem with this indictment would not have it, render there to be no jurisdiction. Your reply brief then gets into the validity of the indictment, which to me seems like a different argument.
well, it's not really, because I would submit that, okay, if there's a defect in the indictment and it robs the trial court of its jurisdiction, then it is a jurisdictional issue. And again, the law is clear that the jurisdiction of a common pleas court, how it gets it over that individual is because there is a return of a valid indictment. So in this case, there is no evidence in this case that this indictment was signed by a foreperson, which in the case law that I cited in my reply brief, it talks about how that's really the only evidence that there is to depend upon to determine whether or not this person was in fact legally indicted. That's absent in this. There's other problems.
I don't think that's being contested. How do we address RC 2941.29 and Criminal Rule 12C2, both of which assert that these errors should be asserted prior to trial, and they were not asserted prior to trial in this case?
My response
Because that really goes down to the...
would be a couple things.
Okay.
Is that first,
Because
Mr.
you're
Thompson
asking,
did
because
object.
in essence, you're asking us to treat it as void versus
Correct.
voidable, and the law seems to direct us that it's voidable and that it's waived once you get into trial. So it's not even voidable at this juncture.
I would respond in a couple ways. First, I would say that Mr. Thompson did object to the jurisdiction of the court, albeit for a different reason.
Yeah, they
that-
objected, well, but that's the thing, it's, as you said, albeit for different reasons, so that doesn't preserve, and I haven't even gotten into that, whether it's been, what review we get, without getting into what review we get, those assertions of jurisdictions, as you already have said, are on different bases.
And even if the court doesn't accept his general jurisdictional objection, we would submit to the court that there is no waiver. You cannot waive an invalid indictment. And I believe it was as it related to waiver, I think it was the Diaz case out of Lucas County, if I'm not mistaken, where it talked about how that issue was brought up, that, hey, this wasn't raised in the trial court, and the Court of Appeals said, well, there is no valid indictment for him to object to, so the fact that he did not object to it is of no consequences in the determination that we're making here. And I think, again, that's what the court should look at. And then even if I'm left to a plain error standard, I still believe that we've met plain error standard because it is a plain or obvious error that affected the outcome of the trial. I'm sure how many people had their hands on this case and nobody noticed that the indictment was missing a signature of the foreperson, that it did not reflect it was a true bill, that it did not have an endorsement from the clerk of court's office. Plain or obvious error. Had that been, again.
Well, that kind of goes against that it's obvious, what you just said.
Right.
Because I think what you're saying is, had it been noticed, it would be obvious, right?
Right. Or it should have been. It certainly should have been noticed sometime prior to trial. I know Mr. Thompson wasn't representing himself throughout this whole process. There were at least, I think, 3 other attorneys that were representing him at the time.
Mm-hmm.
But I don't think that the court could say that because this wasn't raised in the trial court that he somehow acquiesced to this error. Because if you look at the information or the law regarding pleading to information, you can't just acquiesce and say, okay, I'm going to plead by information. You have to
So
not only
Attorney
voluntarily waive your
Attorney
right to the
Perkins, just with
indictment.
respect to you, because of your limited time, do you want to turn to the third and fourth assignment of error?
Yes, Your Honor, if I could. And I think what that comes down to is the fact that he has a constitutional right under the state and federal constitution to be present, any defendant does, to be present in the courtroom. That right is not absolute. It can be lost by the conduct of the defendant. However, the standard is whether or not the defendant needs to be removed from the courtroom because a trial cannot be carried on with him in the courtroom. Where I believe that the error happened in this case is that, first, I don't believe that his conduct was such that a trial could not be commenced without him being present. Second, because the trial had not started by the time when he was removed from the courtroom, then the issue is whether, what should have been addressed is whether or not, do we just go ahead and do we continue headlong into this trial, or do we continue it? And the prosecutor in the case had the right idea. When he was being removed from the courtroom, the prosecutor's like, admits there are provisions for him to be removed, but when you're representing yourself, then they have no representation. The issue, I guess, would be
So I just want to
then,
clarify,
I'm sorry.
I just want to clarify. So the issue you have is with his removal to begin with, from physical removal from the courtroom into the, into the use of the video room in the Justice Center.
Correct.
Okay.
Yes. And then the fact that it was done, that whether there was a basis for him to be removed from the courtroom in the first place, and then if there was a basis for him to be removed from the courtroom, then the matter should not have commenced to a trial. And that, I think, is made clear under the
I think you rely on Meade for that.
Meade case.
Yeah.
So as a judge, when you have somebody who's representing themselves and are not willing to conduct, I mean, I know you're arguing that the court shouldn't have excluded him, but like if we push past that and he's not willing to conduct himself accordingly, what is a judge to do? Just continue, like before the case starts, just keep continuing the case?
I think that is the correct option, is that if they're not conducting themselves and it amounts to.
They'll never get tried then.
Well, if the person is sitting in jail on a contempt holding, then they're going to have to decide, do I stay in jail forever or do I conduct myself accordingly?
It's been the experience of many courts that some of them would like to avoid the trial altogether.
That is true. But
Like
again,
in that circumstance, when the person is simply, refusing, like as a sovereign citizen, when you see that pattern of, I am simply not going to engage, what is the solution for you? That you would just be in this perpetual trial doom loop of Groundhog Day.
well, I'm not sure that you cannot commence a trial because you have a sovereign citizen or a person who believes like a sovereign citizen that they have to make repeated objections to the jurisdiction of the court. I don't think that rises to the level of a threat of imminent danger to the jurisdiction of the court. So I don't think you necessarily need to remove them because they're acting, quote, as a sovereign citizen, as a sovereign citizen does. But again, even if you do remove them, I think Meade placed a restriction on it that, hey, if that person was acting up prior to the commencement of trial, you can't proceed with the trial in their absence. I understand the policy behind if the trial has already started.
Well, initially, the trial proceeds with Mr. Thompson in the Justice Center using the video room. So the
Correct.
trial is commenced with him having the opportunity to participate, just not physically present in the courtroom.
But he was removed from the courtroom, found in contempt and removed from the courtroom before the trial started.
And that's where your issue is.
That's where Meade says, you can do something else, but you cannot start that
So if the
that
trial had started and then he was removed for not obeying the court's orders, then you wouldn't have an issue with that?
Well, it would depend on,
So you'd still be
it would
left
depend on why he was
unrepresented.
removed. I still may have an argument as to whether he was legitimately removed, but it would have been a whole lot stronger case for the prosecutor if it had happened after the jury had already been
Is your
sworn
big
in.
issue the fact that he was left without any representation inside the courtroom?
Yeah, yes, I think that's a huge factor, is that there was nobody in that courtroom advocating on his behalf.
So what does
And-
a judge do, though, when the person clearly wants to, I know you have a Ferretta argument that he wasn't properly advised, but if we get past that and the person wants to represent themselves and they won't conduct themselves accordingly, what should a judge do in that situation?
Are you talking about before the trial started or after the trial started?
Well, I know what your argument is before. You're saying never start the trial, right? But I
Correct.
guess here, if you know, he's banished and he has nobody in the courtroom to represent him. I mean, should the judge have appointed a lawyer to revoked his Feretta status at that point, or?
I'm not necessarily saying that, because I
Okay.
understand that he does have a right, but, you know, I don't know what other than not starting it, I don't know what to.
Okay,
to-
so your
to tell.
issue just is that in this particular case, it shouldn't have been started. If it had already been underway and he was banished, that would be,
That would be a different,
Different
that would be a
situation.
different
Okay.
argument. And again, under those circumstances, I would say it depends on why he was banished in the middle of the trial. But in this case, the record is clear that before that trial started, he was taken out of the courtroom, and there was nobody left in that courtroom to advocate for him. And I think
well, that would be the same thing if the trial was underway and he was banished. He would have that same problem.
You would, but if you look at the reasons why they drew that bright line in Meade, they're like, look, if the trial's already started, we've got the jury here, we've invested assets into proceeding
still have the same
with this trial
problem.
jeopardy.
You have all the same issues that you're arguing here, that he didn't have representation in the courtroom, right?
Correct.
Yeah, so I
But-
don't
but
understand why it's
I'm making
okay
that-
if the trial had already been started, he still wouldn't have anybody in the courtroom.
True. But I think that Meade drew that bright line, and I think that they crossed over the bright line in this case. And that, and if you want to look at, well, again, I've tried hundreds of cases. I can't imagine trying a case by Zoom. As Mr. Thompson put on the record, when he could put things on the record, I couldn't even see the jury on the Zoom. He's doing jury selection, and he can't see the jury? How in the heck is that due process? He would talk about how I'm being muted. I can't say what I want to say because the court is muted. How is that due process? I'm not saying that Mr. Thompson was blameless in this whole situation, but if you look at everything that happened, the rules of evidence weren't followed. I mean, an officer was permitted to testify about photographs that, oh, they just show a hand. Oh, I wasn't even there, but yeah, that's his hand.
Why was
That's a
it-
bindle.
Just going back, because this is the crux of the matter, why wasn't he voluntarily absent?
Why wasn't he voluntarily?
He was I mean, you're arguing that he should never have been removed, right? From the.
Correct. Yes.
And this is the judge was telling him, follow the rules, you're not following the rules, you're not doing what I say, you're out of here.
Yes.
So why is that a wrong thing for her to do? To remove somebody who's not following her rules?
Well, to find somebody into contempt and remove them from the courtroom, you have to find that they're acting in such a way that it constitutes an imminent threat to the administration of justice that may result in the demoralization of the court's authority unless the court imposes a summary contempt sanction. This whole thing started because he refused to sit down. The court indicated that was a safety concern. I don't see how that was necessarily a safety concern. That he wouldn't cooperate when the judge was going through a waiver of a plea form, that he was late for court. All those things I don't think is an imminent threat to the administration of justice. So I don't believe that it reached that level to where he should have been removed from the courtroom.
Thank you.
He didn't use obscenity.
Thank you. You're 5 minutes
Oh,
past your
I'm
time.
sorry.
Thank you.
Thank you.
Good morning, Your Honors.
Good morning.
May it please the court. You can almost, when you read the record, feel sort of some exasperation about this type of case because they're very difficult on how you handle them. And everyone, including the trial court, including the prosecutor, bent over backwards to make sure that Mr. Thompson's rights were protected. And we also have rules, Criminal Rule 43B, that that deals with this situation, when you have a defendant who's not cooperating, who's being disruptive, who's taking discovery and just sweeping it off the table, is interrupting the judge, and has an agenda, because as the judge said on the record that, I've been with you a lot. This case, what lasted 10 months, was on a plea track, and you've been polite, you've been nice, and then all of a sudden, the tables turned, and Mr. Thompson had a different agenda. And he did not want counsel. He was yelling at the judge, interrupting the judge.
But should the trial have been
proceedings.
started? I think that's what Mr. Thompson's arguing, that the trial should have never started.
I don't know how you could write that rule of law, because if you did, how could we ever get any trial started? Yes, he would have been sitting in jail for contempt for 30 days, I guess, and I guess it could have continued. I don't know how
How does
that
this
would
differ
work.
from the Meade case then?
But it's because you have criminal rule 43B, and 43B recognized, Meade was based on 43A. 43B recognizes a situation where you have a disruptive defendant, and you're allowed to proceed, and the defendant can be present remotely. And if the defendant voluntarily, once proceedings are started, decides not to attend remotely, then that's on the defendant. All this was Mr. Thompson's choice. So Meade really only applies to 43A. 43B covers the situation, or else we'll never get to trial. I mean, you'd just be sitting at the jail, I guess, but I don't know how long you could sit at the jail in a direct contempt. I mean, there's some limits to the amount of time you can.
Well, if the person is already not in jail,
Yeah.
I mean, being in jail might incentivize them to cooperate.
To a point, yeah. To a point, it could incentivize them at some point to cooperate, Your Honor, but I don't think our justice system wants that. I think that's why we wrote Criminal Rule 43B, to allow a trial to proceed. Because if they sit there for a long time, you're prejudicing not only the state, because the evidence is going to get stale for a long time, or could get stale. I mean, you're talking about a long, long time. We know how hard it is when a case gets overturned, years later, and we have to kind of cobble together all that old evidence again. And I don't think our justice system anticipates this, that somebody can just sit in jail.
It almost sounds like we don't want to create a situation where the bench is invoking time on the contempt, letting the defendant live out that time before the trial begins, you know?
Right, because then it might incentivize them to continue to subvert justice. Maybe they like the jail better because they have family close by or something.
One thing that I found interesting about the record when I was looking at all the statements that were made by Mr. Thompson, there were a couple statements that it appeared as if Mr. Thompson was articulating that he did not want a trial at all.
Right, I think that's accurate. I mean, that's what's in the record. It's hard to read Mr. Thompson's mind and what really changed his mind about being cooperative to all of a sudden being completely uncooperative. That's anyone's guess, but I think the trial judge, took a very difficult situation and exercised an enormous amount of patience. I mean, the written jury waiver, the judge went over it and tried to get him to sign it multiple times. I mean, we had 2 hearings the counsel waiver. And then a 3rd hearing where they tried to get Mr. Thompson to sign the written waiver form, and he would have nothing to do with it, just kept yelling and talking over the trial judge. The trial judge even had to tell the court reporter, you can't take down 2 people talking, just take down what I'm saying. And so...
Well, rather than proceeding with the trial with him not in the room and having nobody in the room on his behalf, what about if the judge would have revoked his Feretta status on that basis?
I don't know of any authority that allows a revocation of Feretta status, because I know, this is going to show my age, but years ago, Judge Kraft bent over backwards to make sure someone had counsel. And it was reversed under Feretta. And it was a murder case, and we had a similar case also years ago where it was reversed because the judge was trying to do everything to make sure the defendant had counsel because the judge wanted a fair trial and bent over backwards. In those cases.
But was
were
this a
reversed.
situation where the defendant was removed from the room and wasn't cooperating?
Those rules weren't as developed as they are now. Now
Because
we-
this is a distinct situation where you have somebody who's representing themselves but is banished from the courtroom.
Right.
And so I just
Uh,
question.
That's the defendant's choice, you know,
Yeah.
you know, it was the choice to be disruptive. It was the defendant's choice when they set up remote technology that he could attend if he wanted to, he didn't have to attend. Everyone bent over backwards to try to help Mr. Thompson. I mean, even the prosecutor asked for a competency evaluation, even though no one else wanted it, and we got the competency evaluation, and it was determined that he was competent. I mean, there's so many places in the record where you have the prosecutor and the judge and everyone trying to ensure Mr. Thompson's rights, but he wasn't going to have it. And so that is sort of the bird's eye view of this case is, you know, if there was a clear violation of some constitutional right here, if people didn't, all the participants didn't bend over backwards, we could have a problem. But here, that's not the case, and it just would incentivize more of this type of behavior would be my concern. So the state would just ask the court to affirm.
Are there any other signs of errors that you want to address before you step down?
Your Honor, I think all the, I try to cover everything in the
Okay.
brief as best I can. I know there was that one isolated comment by the detective about when it dealt with other acts of evidence. The prosecutor did not
That he had
elicit
murdered, that he was
had
involved
killing.
in.
Yeah, the
murder.
prosecutor did immediately stopped everything and gave a curative instruction. Another curative instruction was given. And the final instructions to the jury. But again, it goes to show you that you had the prosecutor, the judge, and others, the standby counsel, all looking out for Mr. Thompson's rights. I mean, that was a complete kind of surprise, and it was isolated, and the prosecutor immediately asked for a curative instruction. I think the answer that the prosecutor was looking for was a general statement. Generally, we do not disclose the idea of confidential informant. It's just in general, not specific.
So I have a question that I would like your thoughts on.
Yes.
As you know, there are evidentiary errors that are asserted in some of the assignment of errors.
Yes.
And those evidentiary errors occurred such that there wasn't any objection during the time of trial.
Yes.
Okay. Which would subject it to plain error review in front of us.
Yes.
So my question is this. In the brief, there is no request for plain error review on those evidentiary matters. And, you know, courts have been sort of all over the place as, you know, because we don't have to address it, we can address it, we could not address it. What would be your position on that when in an evidentiary assignment of error where no plain error is requested, but it is subject to plain error review, whether you think that our court should be addressing it on plain error or that we should be saying, no, we're not going to address it on plain error because in doing so, we would have to fashion the prejudice ourselves.
Right, I think
I know that was a long thing, but I just want to get your perspective on that.
Your Honor, if it's not requested, then I would be in a position the court shouldn't conduct the plain error review. That it probably is something that needs to be requested. And not only requested, but an attempt made to argue why there is plain error. Otherwise, you know, then, I don't know, that, it's similar to somebody making an assignment of error but not directing the court in the record where that assignment of error occurred.
But you don't argue that in your brief. You go, even though the defendant didn't argue plain error, you went ahead and argued plain error anyway.
And that was my follow-up question, because those moments are not identified in your brief as that this is plain error review, appellant has not requested plain error review, and then directing us to what you think that the court should do, and maybe in the alternative, going to the merits.
Yes. In the future, perhaps we should do that. I think the reason why we do it here is because it was an abundance of caution to try to cover all your bases, but I understand that if we are going to say it's plain error, and we did say, I thought, why it wasn't. Because
You said it
of the
wasn't error,
reaching
yeah.
Of the evidence.
Yeah, but
So
you
we did
didn't-
make an argument.
Right, but you didn't acknowledge if there were moments that, you know,
You don't need
you didn't acknowledge if you believe that this is plain error review, and then in saying that, saying, okay, and it hasn't been requested, and then what do we do with the fact
I
that it was requested, and in the alternative, you see what I'm saying?
I do.
Okay,
Yeah,
so
we
all,
did-
even that very beginning is not within the brief.
You're right. We did not say that there was no plain error review requested, and this court.
And
should
that this
not
is plain
conduct
error. You don't
one.
even identify that it should be plain error.
I understand, yes, okay.
And you understand how that kind of muddles things up a little bit?
Yes.
Or can,
yes,
it might,
can,
it
yeah.
might.
It might, I understand, yes. Yeah, I wish that thought occurred to me. In a case like this, you're a little zeroed in on some of
I mean,
the
I know there were 14
challenging
assignments of
points,
error and so on, but
Yeah.
ultimately, like, I think it muddles it up because,
yes,
you know,
it
we have to
does.
start off with what is the standard of review.
Okay.
And we should be looking at the correct standard of review. And so, you know, one side will say whatever they're saying doesn't mean that that is
Right.
the standard of review.
Right, that's true. And if
Okay.
we say it's plain error.
And that's an
then-
issue of law. The standard of review is an issue of law.
Right, right. So if we don't ask you to conduct a plain error analysis, if it's not been requested by the opposing party, we need to point that out. And if supply case law, if it's, you know, required, but yeah, that, I understand. I'm sorry I didn't, yeah, that, I get it. No.
It's something that, you know, in my head, I'm trying to figure out because it's presenting itself quite a bit
Yes, I can understand that.
beyond
Okay.
this case.
Well, I'm glad I at least know, and I'll make sure that that gets addressed, whether or not the other side, if they don't request plain error review, then I'll make the argument that we do not need to address it. And
I
then,
mean, you could do it, the alternative, address it on the merits, but I think you have to identify what the correct standard of review is, identify whether that's been properly requested by
for
the
the most
appellant.
part, I think on the standards of review, I know what you're saying on this one, but I usually that's in the first paragraph, or we always put the standard review very early on. But yeah, I understand.
Thank you,
I'm sorry.
thank you.
Thank you.
I wanted to see your thoughts on that, and I appreciate.
All right, thanks.
Okay, thank you.
Just briefly, if I could answer your question regarding the revoking the Ferretta rights. The case that Mr. Springman referred to, I'm familiar with, it's State of Ohio versus Gary Smith. The reason why that got reversed was because the Judge Kraft indicated that because this is a death penalty case, you're not going to represent yourself. Other than that, Mr. Smith presented himself as a very competent individual, capable of representing himself, and I think most importantly, he was not banished from the courtroom. He was present during the courtroom. You know, so again, I think that's an important distinction. So possibly, I hadn't considered that, but possibly yes, with him being banished from the courtroom at that point in time, it may have been a prudent thing to do to appoint him counsel versus standby counsel, which could not be in the courtroom.
And you do acknowledge that you don't raise that as error, and you don't
Correct.
argue that as error in
yes.
your briefs?
Yes, I did not raise that as a potential issue, no.
You just raise it as like like part of the prejudice piece, that your client was left
You-
alone left without representation in the courtroom.
Correct, correct.
And then all this stuff happened that you
Correct.
point out.
And a lot of the evidentiary issues, and if I didn't put in there, I'm requesting plain error review. I apologize for that. I will make sure to do that in
Because
future.
the
briefs.
challenge is here is that especially when you're talking about evidentiary things, you have to develop a prejudice. And we're not advocates, so you're basically asking us to develop the prejudice if we're going to address it on plain error. Or potentially, because we can say, well, it's not error to begin with, there's no error, you know, of law, and so there's no error.
Understood.
But do you see what I'm saying?
I
So
do.
yeah,
I do.
so it kind of like, it puts you in a, I think, in a weaker position by not like calling it as it is.
Right, right.
And the state not calling you out on it, you know, like, maybe it doesn't put you in a weaker position, but if they start calling you out on it, then, you know, then you.
Understood. And I think a unique
Because,
thing about.
you know, the reply brief is not the moment to do it.
Right, understood. But I think another thing is that most of those evidentiary issues that I raise, I think all relate back to this whole thing of not having an advocate into the courtroom. That things just kind of went off the track, so to speak.
You know, what's interesting, there's a case from 2002, State v. McAlvin, that went to the Supreme Court. And there, the defendant was asking for a hard rule where if there was a capital case, that there should always be an attorney, you know, and this was one in which the person did proceed, with self-representation, and they wanted a hard and fast rule. And even though it was a capital case, the Supreme Court said no, that the right to autonomy, which they're reading out of the Constitution, that in essence, they're saying that that outweighs the prejudice that is created. So they acknowledge that there is prejudice in self-representation, but the right of autonomy outweighs that prejudice.
Correct, right.
So you know, I don't want to cut you off from your thoughts. I just think it's a very interesting area that has a lot of facets to it.
And I agree, and I know when you look at this case as a whole, you just get a bad feeling about it. You just feel like this wasn't right. I know Mr. Thompson brought along these problems, a lot of them because of his own behavior, but I think he firmly and truly believed in what he was arguing. And if we look at the end result, we look at all the things that took place against him, all the improper comments, things of that nature.
And I don't disagree with you at all, but there's also case law out there where they've looked at these kinds of circumstances and ultimately said if there was any error, that it was invited error, that by the person choosing to, like, you know, to self-represent, well, I think it was these were ones in which the person chose to not engage, that it wound up being invited error.
Correct.
Because he did choose, because here's the thing, he chose, it wasn't just the exclusion of him physically in the courtroom, is him choosing on that second day of trial, which had a lot of the, you know, of the state's testimony, the case in chief presented, he chose not to come back to the video room in the jail.
Right. But I can also understand his frustration if on day one, he can't even see the jury. There's a jury selection going on. He can't even see the jury. He's being cut in and out. I could see the frustration with that whole situation, just to say, you know, to heck with it. I'm getting, you know.
So that's why you're arguing the exclusion from the courtroom into the video room, that the error is there to begin with.
Yes.
Okay.
Yes.
I appreciate you closing that little loop for me.
Thank you very much, Your Honors.
All right, thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. And we wish you both a great afternoon.
Thank you. You too, Your Honor.
Just give me one little second to gather all my trees, all my mini trees. And that concludes the proceedings for today. Thank you so much.